Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I am an Extension Legal Specialist in the Department of Ag and Resource Economics at the University of Maryland. We're back again with another episode. We're trying to get back on track with our normal routine. And again, I need to point out that these new podcasts are being partnered with the Maryland State Bar Association through their on-air legal lab, which is a new network of podcasts that you can go check out. I'll include it in the show notes. And you can see some of the other great podcasts that are being partnered with MSBA, especially those based here in Maryland, looking at some various legal issues as well. So today we're going to dive back into some of the stuff I've been working on over the past few months and discussing in my blog. So today we're going to talk about one in particular that is out of Maryland, out of Garrett County, actually, looking at when a court may rule that an easement by necessity has been created to allow typically access to a property that may become inaccessible. And I'll explain how that can happen here in just a minute as we go through some of the ways this can happen and some of the issues that can lead to this. So typically, a court may grant an easement by necessity as a remedy when an owner splits a parcel into two properties and one of those new properties becomes inaccessible. So we might think about it as one being up here abutting the road, and then all of a sudden we divide it parallel with the road further down, and there may be no way to get to that new property without creating an easement across the property to get to it. The idea is the parties did not intend to create a property unfit for occupancy. So you have to be able to get to it. It's not like we're just magically going to build a flyover or an overpass for you to be able to get to that piece of property. That would still require an easement in some case. So we have to create a way for you to get there. And a recent court decision by the Court of Special Appeals of Maryland affirming a Garrett County Circuit Court decision highlights how a court may handle this issue. This decision is in Gunfield Coal Company versus Carey. And again, I will include a link to the case citation in the show notes, so you're able to find it in the summary of this as well. So what is an easement by necessity? An easement by necessity is defined as an easement created by operation of law because the easement is indispensable to the reasonable use of nearby property, such as an easement connecting a parcel of land to a road. And that comes directly from Black's Law Dictionary. As the definition highlights, an easement by necessity is created when splitting two parcels, or splitting a parcel of land, and one of the parcels created will no longer have access to the road. For example, if Will owns 100 acres and grants 20 acres in the middle to his son Steve, and that acreage has no road access, Steve is going to probably be able to claim an easement by necessity across Will's property to access the road. The rationale for this is that the law presumes that Will's transfer intent was not to make Steve's property unfit for use. The idea is Will wanted him to be able to use it, so he would have, in theory, given him an easement across the property to get to it. The person arguing for this easement must show three elements, typically to prove an easement by necessity. First is a requirement of unity of title. In other words, there was a time that the original owner owned the two pieces of land together. Second, there must be evidence the title was severed. In other words, evidence is needed to show the title was split and separate tracts were created. Third, there must be evidence that it is necessary to cross the property to access the other property. The third element must show this access exists when the titles were severed and as the conditions currently exist. In other words, the party will need to show that the access to the other property has not changed over time. So typically, if the road has been there and the thing changes over time, and it consistently always uses that road is what I'm trying to get at with my inartful way of saying this, probably. So let's get to the background of this case. So this case involves land grants from the state of Maryland to veterans of the Revolutionary War in 1788. It involves a number of military lots in Garrett County. So these are military lots 2058, 2069, 2071, 2070, 2071, and 2079. In 1788, the state conveyed lots 2069 and 2070 to Henry Dodson, and lots 2058, 2071, and 2079 to Thomas Mason. A property survey in 1788 did not include any roads or waterways going through to the lots. So in other words, if we're going back to that third element we have to prove, this is maybe a little hard to do since we don't know exactly where the roads were and the waterways were when these lots were initially conveyed. But we'll continue to go through this because these lots consistently get handed down. In 1843, Dodson died without heirs and his property went to the state. Later, the state sold lot 2069 to Willand and lot 2070 to Winterberg. These were Dodson's original two lots. When Wittenberg took title to 2070, a new survey showed the Castleman River passed through a portion of the lot. Years later, Winterberg granted a right-of-way for a railroad to run through lot 2070. In 1965, Gunfield Coal purchased lot 2070, and Carey purchased lot 2058 and parts of lot 2071 and 2079 in 1988. Pepper purchased lot 2069 in 1992. If I had a map that was good to include in this, I would show it, but the court opinion did not have a good map in it to add in, so I'm just letting that out there. Gunfield's lot is not adjoined by a public road, and there is no deeded right-of-way to access. If we think about it, Gunfield owns 2079, or 2070, and the only thing going through 2070 is a portion of the Castleman River. Since 1965, Gunfield has not used lot 2070 for timber harvest. When Carey purchased his lot, he bought an easement across lot 2069 and another lot to access a public road. Pepper bought lot 2069, an adjoining lot with access to the road. Now, fast forward to the present day, Gunfield brings an action claiming an easement by necessity either across Pepper's lots to access the public road or across both Carey and Pepper's lots to access the public road. The circuit court held that Gunfield failed to prove the three elements discussed above to establish an easement by necessity. Gunfield appealed that decision to the Maryland Court of Special Appeals. The Court of Special Appeals decision goes a little bit like this. So on appeal, Gunfield presented evidence that a common grantor granted the lots in 1788, the state of Maryland. So we think about it, we have a common grantor. The state has never tackled the issue, can an easement by necessity be created by the state? That issue is not resolved in this case. That issue still exists out there. At the time of granting of title in 1788 to lot 2070, the Gunfield lot, the lot became inaccessible without that easement. The issue here is Gunfield failed to demonstrate that the easement by necessity existed in 1788 and that there the property was inaccessible without the easement of necessity at the conveyance. The court agreed with the circuit court that Gunfield produced no evidence that Dodson could not access lots 2070 and 2069 other than crossing Mason's lot. So if we think back to the original grantor, there was no evidence showing that Dodson, to get to his lots, had to utilize Mason's lots. We don't know how Dodson got to his property. Additionally, Gunfield never showed that when Pepper's property, lot 2069, was severed from lot 2070. So think back to when Dodson died. Those two lots would have become severed, technically separated when they escheated to the state, because when the state sold them, they were sold to two different owners. So we now have another split. There was no evidence that lot 2070 was inaccessible other than crossing lot 2069. At the same time, Gunfield never showed that the access was not available to lot 2070 by the Castleman River, which runs through the property. So if it's available through the river, he has access to the property. The property is not unusable. It may not be the best way for him to get to the property, but it is a way for him to get to the property. The circuit court also found that Gunfield was barred by laches from bringing a claim. So let's talk about what laches is first. I know I've talked about it before on other things, but I'll refresh your memory. Laches is defined as an unreasonable delay in pursuing a right or claim. Laches is basically a defense in equity that defendants can raise against stale claims, and is based on the public policy to discourage bringing older claims. In this case, Gunfield bought the property in 1965. The lawsuit's brought in 2018. Gunfield could not explain why it took 53 years to bring the lawsuit for this easement by necessity, something that probably should have been brought when the coal company bought the property in 1965. The court then goes through and looks at what other people that have been claimed that Gunfield was claiming easements against had done. Well, when the Careys bought their property in 1988 and the Peppers in 1982, they bought it, not knowing that there might have to be an easement going across the property. And in fact, both of them took steps to gain access to their respective properties when purchasing them. In the 20 plus years of owning those properties, the Careys and Peppers had no notice that Gunfield was going to press these claims for an easement by necessity, which probably would have impacted the value they bought their properties for. To the court, if they were unaware of this, they might have purchased other properties, or purchased the same properties at a lower price to accommodate a potential easement across the property. So the Court of Special Appeals affirms the circuit court's decision in this case. So, as I often do with these, I like to ask out why you should care. Well, this case highlights a critical aspect for landowners who need to bring a claim for an easement by necessity. If the landowner has an inaccessible property, the landowner should not wait to bring that lawsuit. Here, Gunfield waited 53 years without explaining why they waited 53 years. Another reason to highlight this case, it's the path taken by the Peppers and the Careys. Both purchased inaccessible lots, but worked with neighboring landowners to negotiate an easement across the adjacent properties to access the public road. Yeah, it might be easy to go to court in some people's eyes and get an easement by necessity, but just realizing you may need to negotiate that early on in the purchase might make this a little easier to do, and this might ensure future owners have better access to the property and potentially could increase the resale value of the property by having that easement. These are all things to take into consideration. So thank you again for listening. If you have questions for me, you can email me at lgoering@umd.edu, or you can tweet me at aglawpaul, or follow me and send me messages on Instagram at the same handle at aglawpaul. Again, if you're curious, I will put links in so you can check out the MSBA's their new official podcast, Insightful Voices, as well as all their other partner podcasts through this on-air legal lab that they are now hosting through the Maryland State Bar Association. So thank you again for listening, and enjoy the rest of your day.